Today, we're going to crack open a real legal mystery. It's all about a massive shipment of Sony electronics that just, poof, disappeared. And it all leads to a huge Supreme Court decision that had to sort out a very messy game of who's to blame. So this is the number that kicks off our whole story. Nearly 7.3 million pesos. I mean, think about that. That's how much the Sony stuff was worth when it went missing somewhere between the port in Manila and a warehouse. That's a huge loss, and you just know somebody's got to pay for it. And that really gets us to the big question, the one that pushed this case all the way to the Supreme Court. When a shipment this valuable just goes missing, who ends up paying the price? Okay, let's start at the beginning. We're going to lay out the vanishing shipment, a routine delivery that went so wrong. These are the facts that nobody disputes, the simple chain of events that everyone agrees happened. So check this out. It's October 7th, 2000. A big Sony shipment lands at the port. Their broker, a company called TMBI, hires another company, BMT Trucking, to actually haul the goods. Simple enough, right? Well, 4 trucks pick up the cargo, but because of a truck ban, they have to wait until Monday morning. And that's when things get weird. On Monday, only 3 of the 4 trucks show up at the Sony warehouse. By noon, that 4th truck is found, abandoned. The driver? Gone. And the cargo? Totally vanished. So the cargo's gone and Sony's insurance company is on the hook. You can imagine the hunt to find someone responsible started immediately. And of course, in this million-dollar blame game, nobody wanted to be the one to pay up. And this is where it gets interesting. You've got the broker, TMBI, pointing the finger at the trucker, BMT. TMBI is saying, hey, we're just brokers, we only do paperwork. And BMT is firing right back. We were careful. It was a hijacking. But look at this. What's the one thing they both agreed on? They both claim the hijacking was a fortuitous event. That's a fancy legal term that's basically an escape hatch. If they could prove that, they could both walk away without paying a dime. Okay, so to solve this whole mystery, the court had to get really specific about how the law defines who's responsible. It all boiled down to 3 really key legal ideas: carrier, diligence, and chance. This is where the real legal detective work kicks in. First up, what in the world is a common carrier? Well, TMVI tried to argue they weren't one. They were like, we just do paperwork, we don't even own the trucks. But the law is actually pretty broad. It says if you're in the business of transporting goods for the public and you get paid for it, guess what? You're a common carrier. And that means the law holds you to a very high standard. And here's the real kicker. This quote is from TMBI's own general manager, admitting under oath that their business eventually delivers the cargoes to the consignee's warehouse. I mean, wow. The court saw that and found it super compelling. It really doesn't matter if you hire other people to drive the trucks. If you offer delivery as part of your service, you fit the definition. Now, here's the thing. Being labeled a common carrier comes with a huge responsibility. The law requires you to use what's called extraordinary diligence. And this isn't just about being a little careful. No. This is the absolute highest degree of care the law recognizes. So the big question for the court was, did these guys actually meet that incredibly high bar? And that brings us right back to their main defense. Was the hijacking a fortuitous event? Remember, both companies were banking on this. They claimed it was basically an act of God, something totally out of their hands. But legally, that term is super strict. It means something that's literally impossible to see coming or to avoid. We're talking earthquakes, floods, that kind of thing. It's not just any old robbery. In fact, the law is crystal clear on this. There's a list of only 5 specific situations where a common carrier gets off the hook for lost cargo. Take a look. You see natural disasters, acts of war, but you know what's not on that list? Hijacking or robbery. To use that defense, the carrier has to prove the robbery involves something like grave or irresistible force, making it a truly unforeseeable event. A very high bar to clear. All right, so with all that legal groundwork laid out, how did the Supreme Court actually apply these ideas to the facts of the case? Let's break down exactly how they got to their final decision. The court's logic was really a straightforward 3-step takedown. First question, is TMBI a common carrier? Yep, their own manager said they handle deliveries. Done. Second, did they use extraordinary diligence? Big nope. And here's a jaw-dropping detail the court pointed out. They took no extra security measures, even though they'd had another Sony shipment hijacked in a really similar way before. And finally, number 3, was this a fortuitous event? No, they never brought any proof of serious violence or overwhelming force. They just didn't have a case.
So when you put it all together, TMBI was a common carrier that completely failed to prove they acted with extraordinary diligence, and they failed to prove the loss was because of a true fortuitous event. In that situation, the law just presumes they're at fault. The verdict was in. TMBI was on the hook to the insurance company for the full 7.3 million pesos.
But wait, the story isn't quite over. We're getting to the final twist in this chain of liability. The Supreme Court added one last fascinating layer that explains how the blame and the bill flows down the chain from the broker to the subcontractor who actually lost the stuff. You might be thinking, okay, so do TMBI and BMT just split the bill? That seems fair, right? That's actually what a lower court had decided. But the Supreme Court said, not exactly. The law is actually more specific about why each party is liable. It's not about just splitting it down the middle. You have to look at the contracts. Who had a direct agreement with whom? That's what really matters. So here's the key legal distinction the court made, and it's between two types of fault. TMBI's fault was what's called a breach of contract. They had a deal with Sony to deliver the goods, and they broke that deal. It's that simple. BMT, the trucking company, well, they didn't have a contract with Sony. So for Sony to go after BMT directly, they would have had to prove negligence, which is a whole different and much harder thing to prove in court. This creates this really clear chain of payment, and the court laid it out perfectly. First, TMBI pays Mitsui, the insurance company, for breaking its main contract with Sony. But then, in step 2, TMBI can turn right around and sue BMT to get that money back, because BMT broke its own subcontract when it lost the cargo. So you see how that works. In the end, the proverbial buck stops with BMT. They were the ones who actually had their hands on the cargo when it disappeared. So while TMBI is responsible to its client, BMT is ultimately responsible to TMBI. And this whole case leaves us with a really big question. If you hire someone to do a job, are you responsible for their mistakes? This case shows that in the eyes of your client, the answer is often a resounding yes. You can't just pass off the responsibility. It makes your choice of who you subcontract to and the contracts you sign with them absolutely critically important.